For those of you who have attended this presentation before, you're going to see some of the same stuff, but I think it's, kind of good to review every year and level set as to where we are with the state of the law, in addition to a couple of updates from where we were at this time last year based on what has happened over the last year. So as some of you may know, and as Grace said, my name is Kristina Launey. I'm an attorney with Seyfarth Shaw, and I do disability access, litigation, and counseling, and have a special experience, a specialty in website accessibility, digital accessibility, and Title III of the ADA, obviously. So with that, we're going to click it to our legal disclaimer, and what you need to know from this slide is this is purely information we are providing today. This is not legal advice, this is not legal opinions, and it should not be construed as that. So with that disclaimer, we'll jump into a quick overview of what we're going to be talking about today. So like I said, we're going to level set with a review of the state of the law, essentially the background. What is the foundation of what we are talking about with respect to website accessibility under the applicable federal and some state laws? What does it mean to have an accessible website? I know probably 99.9% of you out there know exactly what that means from a technical perspective, so we're not going to belabor that, but we'll just hit a couple of high points for those who might be new to it. Then we'll talk about the lawsuit data. I say on the slide here, website lawsuit data. We're going to talk about the lawsuit data of Title III lawsuits as a whole, so on all bases, not just digital accessibility. And then we'll do a little bit on website data. We're finishing crunching our numbers on the 2021 data, so we'll give a preview of that in addition to the 2020 data. We'll talk about some key lawsuits and settlements in the digital accessibility area. And we'll close with strategies for avoiding and defending legal actions and a typical roadmap to accessibility. So we will do all of that hopefully in 40 minutes so we can allow some time for questions. The legal overview. So at its very foundation, what laws exist that might require accessible technologies? Well, we have Title II of the Americans with Disabilities Act. That applies to state and local governments. Title III of the Americans with Disabilities Act applies to places of public accommodations. We'll talk in a minute about what those are. But essentially private businesses. And we're really going to be focused on Title III throughout the presentation today. We also have Section 504 and Section 508 and Section 503, that's not on this slide here, of the Rehabilitation Act. Section 504 applies to recipients of federal funding. Section 508 is the section that essentially says that technologies sold to federal agencies. It's also incorporated into Section 504, such that recipients of federal funding who use technologies in relation to those engagements may need to have those technologies be compliant with the accessibility requirements of Section 508. Same thing with Section 503 as to federal contractors. And then we have state non-discrimination laws. The most common ones we see popping up these days in litigation are the New York state and city human rights laws. And then in California, we have the Unrest Civil Rights Act and the Disabled Persons Act. We'll talk a little bit more about those later. And then there's also a good number of state laws that apply to state contractors, similar to the Rehabilitation Act. Some states require the technology that's provided pursuant to a state contract to be accessible. The Air Carrier Access Act requires that the primary websites of airline carriers conform to the WCAG 2.0 AA. And the Affordable Care Act, Section 1557, the Medicare regulations, those apply to healthcare. and those also require accessible technologies. I mentioned those three rather industry-specific laws at the end because, as you'll hear in a couple minutes, there is not a set standard in a regulation, in a statute that applies to all businesses to require they meet that standard to make their websites accessible. But there is such a standard in some laws, like the Air Carrier Access Act, like the Affordable Care Act, like the Medicare regs, like Section 508 of the Rehabilitation Act. So, like I said, we're going to zero in on the Americans with Disabilities Act. That's really our focus today. What is the Americans with Disabilities Act? Everyone's so familiar with the acronym, the ADA, but what is it? Well, it's a federal civil rights law that prohibits discrimination against individuals with disabilities. It's been in effect longer than my math with this new century can really go. 30 almost years now since we're in 2022. President George H.W. Bush signed it into law, and it covers 5 key areas. And this is actually it seems somewhat elementary, but I think it's actually very important to know the 5 areas that the ADA covers because folks often get them confused. Title I of the ADA applies to employment, employer-employee relationships. Title II, as we mentioned a minute ago, applies to state and local government activities. Title also public transportation. Title III applies to places of public accommodation, which again are essentially private businesses. And then Title IV applies to telecommunications. So as I noted, our focus today is going to be Title III. We'll refer to Title II every now and then, but also keep in mind, we're often asked, well, my website has to be accessible to employees. That's a different law that applies there. That's Title I of the ADA, and it's a different standard that applies there than under Title III of the ADA. So there would be a different analysis. So under Title III of the ADA, here are the main requirements of the law. First of all, Title III requires that public accommodations have facilities that are accessible to individuals with disabilities. And remember, we say Title III essentially applies to private businesses. So that means, the customers of the private businesses, members of the public, when we're talking about the individuals with the disabilities to whom the statute is really intended to provide access. So accessible facilities, we're talking about, ramps. We're talking about all of the things when you go into a storefront that need to meet the specific requirements of the ADA regulations. They're very, very specific, down to the quarter inch sometimes, as to how a facility has to be constructed, how that facility has to be maintained to comply with Title III of the ADA. The second component of Title III of the ADA requires that public accommodations make reasonable modifications to policies, practices, and procedures when necessary to ensure that individuals with disabilities have equal access to the public accommodations, goods, services, facilities, privileges, advantages, and accommodations. What does that mean? It means if you have a policy of, we saw it a lot with masking when that came up. If you have a policy that required everyone to come into a store to wear a mask, then you might need to find a different way to serve people who could not wear a mask due to their disability, whether it be curbside service or some other modification of a policy to try to provide equal access to the goods and services. The third component here is really what we're going to be talking about today. And that is that the ADA requires that individuals with disabilities provide effective communication to individuals with disabilities by providing them with auxiliary aids and services at no additional charge. So while the ADA regulations and the ADA statute, as you'll probably hear me say over and over and over again, do not specifically state that websites must be accessible, do not specifically state how a website must be coded to be considered accessible in accordance with the law, what the statute or regulations do say is that one of the types of auxiliary aids and services that may need to be provided is accessible electronic information technology. And that could include websites, could include mobile apps. That's the main provision we are looking at when we are talking about website accessibility under the ADA. The other provision that we see folks cite quite a bit is the most fundamental provision of the ADA, which is that public accommodations provide equal access to individuals with disabilities to their goods and services. So what are the remedies? If a business violates Title III of the ADA, what are the potential consequences? Well, when we're talking about just an individual who might file a suit against a business, that individual could recover or require, in the first instance here, on the slide here, we have the first thing being injunctive relief. So that means that the individual could get a court to order that the business make the website accessible, essentially fix whatever the accessibility barrier is. That's the injunctive relief. The individual can also recover attorney's fees and costs incurred in bringing the legal action. That's why we see a lot of these lawsuits settle very quickly out of the gate, not because of the potential of huge damages to a plaintiff, because under the ADA, there aren't any damages available to be recovered. It's really the longer you litigate, the more you could potentially have to pay in attorney's fees and costs. Now, under state laws, under the New York laws and under the California laws, there is the possibility that the individual can also recover damages or penalties. And that's part of the reason why we see so many lawsuits filed in those courts, as we'll talk about in a couple minutes. If the DOJ decides to pursue an enforcement action against a place of public accommodation, then it can recover penalties against the business, which, those penalties, when a couple of years ago, when it was first issued, were $75,000 for a first violation and $150,000 for every violation after. That amount has gone up over time. So presently $96,000 for a first violation and $192,768 to be precise for a subsequent violation. The DOJ can also get a requirement from the entity, from the business, that it fix the website, and potentially damages as well for any individual who suffers any damages as a result of the conduct. Note that these are often negotiated. So when you see any DOJ settlement agreements posted on its website, the numbers might be different, and that's why. So the reason why I have the slide up that is up now, and what this slide says, it's ADA background of public accommodation is, and then it unfortunately is a very dense slide because we are copying here what the definition of a public accommodation is from the statute, from the regulations. And the reason why this is significant, and I'll let you read it in the slides when you get them, other than me reading it to you here, because we're not going to go into detail on this slide. But the point of listing here the 12 different categories of places of public accommodation is to know that for an entity to be subject to Title III of the ADA, it needs to fall into one of these categories. It needs to be a place of lodging, an establishment serving food or drink, for example, a place of entertainment, for example. And we have seen some creative theories from plaintiffs' attorneys lately against entities that aren't falling into one of these 12 categories, that might be a manufacturer of a product, for example, rather than an entity that provides a good or service to the general public. And so sometimes we do have to go back to the statute and the regulations and say, hey, this entity is not subject to Title III of the ADA. It's not who the statute was intended to apply to. Also significant on this definition of what a place of public accommodation is one of the most debated, most litigated aspects of this law, which is, does a website have to be, well, I guess more fundamental, I should say, can a website even be subject to Title III of the ADA? First question. If the website is tied to a physical place of business, then does that make the website subject to Title III of the ADA? Or are only physical places of business, because of the language in the statute being a place of public accommodation, subject to Title III of the ADA? And that's a question we're going to talk about as we talk about the case law in a minute, that has a different answer depending on which court is deciding the issue. Makes litigating in this area, it also makes just knowing what the law is for folks who aren't litigators a little bit confusing sometimes. You need to know what part of the country you're in, what court might be deciding the issue. A quick preview of that. The Ninth Circuit, which generally is the West Coast states, California, Oregon, Washington, and more, says that a website to be subject to Title III of the ADA has to be connected to a physical place of business. The 11th Circuit, which most notably covers Florida, also says, yes, there must be a physical nexus, with maybe a little more required, as we'll talk about. The Third Circuit also says yes. The First Circuit says no physical nexus required. In other words, a web-only business could be subject to Title III. And as you probably guessed, there's more than just those four circuits. The circuits go in order, first, second, third, fourth. So we're missing some circuits, right? And that's because when we talk about circuits, we're talking about courts of appeal. We have federal trial courts. Those are called district courts. And then the next court up, if you appeal the decision of the trial court, is a circuit court. And we don't have that many courts of appeals that have decided this specific issue, only these four here. Quick review of what it means to have an accessible website. Well, it's one that can be used by people with various types of disabilities. And on this slide, we have a couple of examples, and we have just a little graphic of two different computer screens, one showing barely no contrast at all, and the other showing, a pretty clear contrasting photo of a person inside of a circle, very dark black against white with a check mark. So for people who are blind, we want to make sure that the website is coded so that it can be read essentially by the screen readers that are used. That means having alternative text for images, properly labeled form fields, proper use of headings, keyboard only access, and audio descriptions for videos if accessible. Those are some of the most common issues we see popping up in demand letters and lawsuits, although obviously there is quite a bit more to it than just those examples. Low vision, we want to make sure color contrast and text resizing are covered. For people who are deaf or hard of hearing, captions for audio content. For people who have mobility related disabilities, we want to make sure we have keyboard only access as well, and the ability to slow down or turn off timeouts. For people who have epilepsy, no flashing content. And for people who are colorblind, make sure that color is not the sole method of conveying information. Again, just examples of some of the either barriers or some of the things that need to be considered in coding and maintaining a website to make sure it is accessible for people with various types of disabilities. How do you know how to code a website so that it is accessible, especially because the ADA does not tell you that? Well, there are a set of guidelines, a set of criteria into guidelines that I'm sure you've heard about in every single session, and you will hear about in every single session of AXCON. They are called the Web Content Accessibility Guidelines, the WCAG, the WCAG, the WCAG, the I forget how else they're pronounced depending on what part of the country or world you are in. But the WCAG guidelines, as you all know, published by the World Wide Web Consortium, and a private group of experts. They were developed quite a while ago, even though, some businesses had said we really weren't aware of these. They have become much more well-known in the past couple of years. And at least amongst, the world at large, of course, amongst the accessibility community, they've been known for quite a while. Most recently, as you all know, June 2018, the 2.1 set of criteria came out on top of the 2.0 criteria. 2.1 adds 17 success criteria to 2.0. And I say this even though I'm sure all of you know this, but we're quite often asked by clients, by businesses in their website accessibility efforts, do we need to conform to 2.0 or 2.1? What's the difference? We get asked all the time, what's the difference between A, AA, AAA? So knowing the difference in terms of the additional criteria that 2.1 adds is pretty important. And again, you see in the last bullet here, not a legal standard under Title III of the ADA. And it really is important to remember that, because that is really the source of so much of the litigation we have right now. It's the uncertainty with there not being a set standard in Title III of the ADA, in contrast to, as I mentioned before, the physical accessibility, very specific standards that are in the regulations, and also in contrast to the Air Carrier Access Act and some other laws that do clearly have a standard set. Okay, quick review of why we don't have a standard set for website accessibility under Title III of the ADA. We've covered all this before, but it's just, I always think it's very interesting to know why we are where we are. When Obama was president, which seems like a lifetime ago, right? We had an advanced notice of proposed rulemaking that the Department of Justice, which is the enforcement agency for Title III of the ADA, had put out. We call that an ANPRM for short. And it pended, was that a word? It was pending the ANPRM for 6 years, 2010 to 2016. And, right when everyone was getting pretty discouraged about whether it was actually going to finish the regulatory process, the DOJ said, you know what, let's do a supplemental advance notice of proposed rulemaking, an SANPRM, and get additional comment from the community about how much time businesses should have to comply with the new regs, the impact of a requirement to caption all videos, what standard should be adopted as the definition of accessible. Should it be the WCAG 2.0 AA or something else? And, so all this time, no proposed regulations, but the enforcement arm of the DOJ kept enforcing the ADA as if, there were a specific requirement applicable to website accessibility. And in their settlement agreements, they largely required the WCAG 2.0 AA as the injunctive relief measure, essentially. And so those two arms of the DOJ were somewhat proceeding separately. Then Trump DOJ comes in and says, we're going to withdraw all rulemaking efforts. And we saw little to no action during the Trump era on website accessibility naturally. We did see some back and forth a little bit between the DOJ and some Congress people saying, hey, you enact regulations, DOJ, and DOJ saying back to Congress, no, you're the lawmaking body, you enact a law to fix the website accessibility confusion. And as a result, nothing happened. In comes the Biden DOJ. We now have Kristen Clark as head of the Civil Rights Division. We expect lots of pattern and practice cases and demands for remediation, damages, and monitoring, sort of a return to the enforcement era that we saw under Obama. Haven't seen a whole lot yet, but they're still getting up and running and have had a lot of other things on their plate. We have seen, though, increased activity from the Biden DOJ. For example, We've seen statements of interest, which are essentially the DOJ filing something in a pending lawsuit saying, hey, this is a topic of interest to the enforcement agency charged with enforcing Title III of the ADA. So we think that you should hear our opinion of what the issue is here. The statements of interest that the DOJ has participated in or has filed in lawsuits have been about bed height in hotels, about kiosks, which is, you know, a close corollary to what we're talking about here. You need to make sure that any technologies used in the kiosks are accessible, plasma donation, and the Texas anti-mask executive order from 2021. So the DOJ has been more active on the accessibility front, but not any movement that we've seen on website accessibility regulations yet. On February 28th, so about 2 weeks ago, I guess that's way too singular, precisely 181 advocacy groups led by, you know, some of the fairly prominent ones like NFB sent to the DOJ a joint letter to enforce accessibility standards, asking the DOJ to, you know, get in gear and start the process toward adopting enforceable online accessibility standards by the end of the current administration. You know, knowing that this can't happen overnight, but come on, let's get this process started and hopefully finally adopt some regulations to provide some certainty and some guidance, both to the community of individuals with disabilities who need accessible websites, but also to businesses so they know what they need to do to be considered in compliance with Title III of the ADA. So we will see if we will see any action on the regulatory front in the Biden administration. I promise you numbers. So here are our numbers for all ADA Title III accessibility lawsuits. On this chart that's on the slide here, we have the total number of ADA Title III federal lawsuits filed each year from January 1st, 2013 through December 31st, 2021. And I'm not going to cover all of them. You'll get all of them on the slides when you receive them, or you can go to our website, our blog, and check them out. But the most notable points to be taken from here are in 2013, we saw 2,722 lawsuits filed. 2014, that number more than doubled to 4,400. And then 2016, we had a 38% increase from the year before, up to 6,600. 2017 went up to 7,600. 2018 went up to 10,000. 2019, 11,000. And while 2020 went down 1% in our pandemic year from 2019, 2021 went up to 11,500 lawsuits. That's filed on all bases under Title III of the ADA, not just website accessibility, but you can see, you know, the huge increases year over year over year. As far as states, as to all Title III lawsuits, California led the pack in 2021 with 5,900 lawsuits. New York was second with 2,700. Remember those statutory damages that I mentioned a little while ago? That is likely driving those lawsuits. Florida was in third place with 1,000. And then when we talk about, well, the next chart you can actually see when you get the data or on our blog. The next chart talks about year over year looking at those states. What it essentially shows is New York has grown in numbers over the year. Florida's gone down in numbers over the years, and California has, you know, like I guess like our mountain range out here, it's steadily been climbing year over year over year since 2013. And by month, the lawsuits spiked in March, spiked in November, and then went down in December. The month by month are just always interesting to see the activity there. They didn't take Thanksgiving week off, I guess, last year. Website numbers. In 2020, we saw in the number of ADA Title III website accessibility lawsuits filed in federal court, we saw them up 12% from 2019. In 2019, the number of website accessibility lawsuits stayed pretty flat to 2018, but 2018 was an almost 200% increase over 2017. So in 2017, we saw 814 such lawsuits. In 2018, we saw 2,200 website accessibility lawsuits filed in federal courts. In 2019, we saw 2,200 such lawsuits. And then in 2020, we saw 2,500 such lawsuits. As I mentioned a minute ago, a while ago now, we are finishing crunching our numbers for 2021, and we will have them published on our blog soon. But it looks like we're going to see a 14% increase in lawsuits filed just on the topic of website accessibility, just in federal courts, to 2,800, which is a 14% increase over 2020. So, we've recovered from the 2019 levelness and seeing quite a bit of increase. As to where we're seeing those lawsuits filed, well, actually here I have the state by state data first, as you can see when you get the materials. In 2020, month by month, April was a dip, and then the lawsuits climbed and climbed and climbed for the most part, dipping in November slightly, but otherwise climbed out for the rest of the year, finishing with the highest filings in a single month in August and then December at 300 and 299 for 2020. In 2021, interestingly, the chart is pretty flat. We have 234 in January, we have 329 filed in March, and it's pretty flat line until you hit November. And in November of 2021, there were 499 website accessibility lawsuits filed in federal court, which I think is fascinating and is usually due to one firm filing a heck of a lot of lawsuits all at once. Top states, website accessibility. New York topped the charts with 1,600, almost 1,700 in 2020, followed by Florida with 300 and California with 223. In 2021, New York still led the pack with over 2,000 lawsuits, so just under 400 more than in 2020. California overtook Florida. California went up to 359, give or take, and Florida went down to 185 in the state count for website accessibility lawsuits filed in 2021. As noted, we're not completely done with crunching our numbers, so those are rough numbers, but stay tuned to our blog and we will be posting those numbers when they are final. Okay, I am moving too slowly, so I'm going to move a little more quickly so I allow a little bit of time for questions. But some of this here is going to be review as well, but they're still the same themes that we saw in 2021 that we saw in 2020. Unfortunately, kind of a little more of the same confusion. So here are the main themes. Are web-only businesses covered public accommodations? Are they covered by Title III of the ADA as a place of public accommodation? I mentioned this earlier, right? Federal courts disagree about this. The 9th Circuit and 11th Circuit says web-only businesses are not covered. The 9th Circuit follows a nexus test. There has to be a nexus to a place of public accommodation. The 11th Circuit, Florida essentially, in Winn-Dixie, which has 2 asterisks by Winn-Dixie, said that a barrier on the website must prevent access to the accessing of goods and services at a physical location. So even a little bit farther than just requiring there be a connection to the physical location. Note that some state courts disagree with these positions. These are the federal court positions. The 1st Circuit, businesses do not have to have a physical location serving customers to be covered. So a web-only business can be subject to Title III of the ADA, as some district courts have said. Another theme that we've seen is some businesses saying, well, I've entered into a settlement agreement, so plaintiff number 2, you can't sue me because I've already settled a case regarding the accessibility of my website, courts pretty universally say that a prior settlement agreement promising to make a website accessible is not a bar to a subsequent lawsuit. A consent decree, which is a court order, could be a different story. Being in the process of making your website accessible does not usually render the case moot. What we mean by moot is there's nothing for the court to decide. You know, you wanted an order for the website to be made accessible. We've made our website accessible, so there's nothing for the court to decide. That's essentially what mootness is. Some courts have said, yes, you're in the process, you've made the website accessible. I accept what your expert says. I consider this lawsuit moot and dismiss it. Other courts have said, no, I think that maybe, you know, websites are dynamic. It could fall out of being accessible again. So I'm not going to dismiss the lawsuit as moot. But where you just say we're in the process of making it accessible, courts pretty universally say, yeah, you're not done yet. The website is not accessible yet. So we're not going to dismiss this lawsuit as moot. Final theme here. If the plaintiff can't ever use the services of the business whose website is not accessible, then the case might be dismissed for lack of standing. And a court can't decide a lawsuit if the plaintiff does not have standing to pursue it. That means the plaintiff must have suffered some sort of injury by virtue of the violation of the law and be at risk of suffering injury again in the future. If the plaintiff can't show that, if they can't show that they encountered a barrier or might encounter a barrier in the future, then they aren't eligible to pursue the lawsuit. And where we've seen those arguments work is where the plaintiff never could have used the goods or services of the business they're suing. For example, credit union cases where you had to live in a certain region or you have to be a member of the military to be able to even use the goods or services of the website. Key cases and themes. So Roblox versus Dominos, we have to keep this case in our slide deck, even though, you know, it seems a bit old now from 2019. And that's because there are so few substantive decisions still on the topic of website accessibility. As you all know, in the Domino's Pizza case, there was some back and forth between the appeals court and the district court. Ultimately, the appeals court found that the ADA applies to websites and mobile applications that have a connection to a physical place of business. They rejected the argument that Domino's has made that it's not fair. The DOJ hasn't enacted regulations. You can't hold us to any requirement that a website must be accessible absent those regulations. The Ninth Circuit said, no, you know, we have other provisions in the ADA that put you on notice that if you are communicating with individuals with disabilities, you need to be communicating effectively in an accessible manner. And also discussed in the Domino's case was whether telephone service could be an alternative to an accessible website. And while the Ninth Circuit said it couldn't decide that at the certain procedural stage, later on in the case, the court had found that having to wait on hold for 40 minutes on the telephone is not considered equivalent access to being able to order your pizza online pretty promptly. This case is actually still going on in the district court, in the trial court, so we're following it. But after all this up and down and some substantive decisions from the appeals court, the case itself still is not over. Winn-Dixie saga. I'm sure you all have been waiting to hear about this. It's a whole lot of nothing at this point, unfortunately. You know, after 2017 to 2022, a very long saga. The beginning of the case was with really a trial in front of just a judge. That means that's what a bench trial means, where the court issued a 3-year injunction to Winn-Dixie saying, make your website accessible according to the WCAG 2.0 AA. Train your employees on web accessibility. You're responsible for third-party content on your website being accessible if it's used to provide your goods and services via your website. That was very significant at the time. Adopt a web accessibility policy and pay the fees and costs to the plaintiff who was the prevailing party. It was appealed the 11th Circuit in 2021 took this, pretty extreme position from what other courts have, which said not only does there have to be a physical nexus to the website must have prevented the plaintiff from accessing the physical facility or goods or services in the physical facility, which, was a pretty big deal for that decision to have come out of the 11th Circuit. Remember on the prior slide, I had asterisks by that rule in the 11th Circuit. The reason why is because the plaintiff then asked a panel of judges to review that decision. The 11th Circuit in December of last year, in response, dismissed the appeal, saying it was moot because the website was now accessible, and sent it back down to the trial court to dismiss the case, saying there's no case for us to decide here anymore. The website is accessible. And then when Dixie appealed that, essentially saying, hey, I want a bigger panel of judges to decide this. And the 11th Circuit said, okay, maybe we'll reconsider it. But then on March 2nd of this year, the 11th Circuit said, nah, we're not going to reconsider that decision. So the case is done now with not much to show for it after all that saga, unless either party decides to appeal to the US Supreme Court, which we think is pretty highly unlikely at this point. I'm going to flip through, and I guess, Grace, speak up if we have questions. If not, I'll flip through a couple more slides and leave about 5 minutes for questions.
Yeah, we have quite a few questions, so as many as we can get to.
Okay, great. So let me just flip through these last couple slides, because you all have seen this before if you've attended this presentation before. And I've got a couple of new ones here, but they're all along the same theme. So Gomez versus GNC is out of the Southern District of Florida. It was stayed pending the Winn-Dixie case. It is still stayed. The court had ordered it to notify the court within 10 days of Winn-Dixie. It doesn't appear that it's done so. GNC had filed a suggestion of bankruptcy in the meantime. So who knows if that case is done. This case was a cautionary tale for choose your experts wisely, though, because summary judgment here was granted for the plaintiff after expert reports were submitted and the defendants, was not exactly what we would want to see. Under the California UNRRA Act, we still have the Whisper Lounge case up here because even though it was a 2018-2019 case, again, it's one of the few cases that gives an actual substantive decision. And this court, and it is an appeals court decision, which means it's binding on lower courts in its same area. And it said that a website that is not accessible violates the California UNRRA Act, which is the equivalent of the ADA. It required the website to conform to the WCAG 2.0 AA and pay statutory damages. This court also held that websites with a physical nexus are subject to Title III of the ADA. We've seen some California state courts go the way of saying that web-only businesses are subject to Title III of the ADA. So while in federal courts in California, the rule is there must be a physical nexus, the courts in California have been a little more diverse in their ruling on that topic. Also, we have some discussion of third-party content in the Thurston case as to whether the website owner can be responsible for that. And here, the telephone and email, whether they can be alternative means of communication, was discussed here as well. But here, the court found that no, telephone is not effective alternative means of communication because it's only available during the restaurant hours of operation. We have seen quite a few other cases kind of consistent with some of those themes, but again, they've been trial court cases, which is really the theme in ADA Title III and equivalent state court cases. Just know what court you're in, because we still don't have a US Supreme Court case on the topic. So you need to know what the rule is in the courts where you're litigating. One recent case from last year, Thurston versus Omni Hotels, where the court said that a plaintiff needs to have an intent to actually, use the services of the business, to have a valid claim, which is somewhat a point of law that we don't have a whole lot of authority for. And the remainder of the cases we have here are ones that we've talked about in prior presentations, because the principles remain. And we've talked about all these principles earlier on in the presentation anyway, with our general themes, the physical nexus, the mootness arguments, and in the interest of time, I'll move to questions, but I'm more than happy once y'all look at the materials and look at the specific cases that we've cited here in the slides. If you have any specific questions, I'm more than happy to answer them for you. Like I said, we've already covered the themes that are drawn from each of these specific cases we have here in the presentation. The strategies, as I wrap up and turn it over to Grace for a couple of questions, for avoiding and defending litigation, obviously creation and maintenance of a website and mobile apps that are accessible, having a 24/7 telephone line that's available, having an accessibility statement, policy, and procedure, training on accessibility for your tech people and your customer service, anybody who's customer facing. Look at your vendor contracts for accessibility built in and make it specific. Look at your third-party content that you're using to provide your goods and services on your website. Is that accessible? The consent decree, we talked about that versus a settlement agreement. That could be a proactive measure. You'd want to talk to your attorneys about that pretty carefully. Be careful with links to third-party websites and, again, third-party content on your website. And then get help. Qualified accessibility counsel, somebody who knows accessibility as your attorneys to help you with this, a qualified digital accessibility expert like DQ. Be careful of privilege, attorney-client privilege issues, manual and automated testing, not just automated testing, and training. Again, know and understand the WCAG guidelines and criteria and levels. And this isn't a one and done. It is a continuous process. So partner, with your attorneys, with your consultant, and with your internal team to keep accessibility going. So Grace, with that, I know, and apologies for taking most of the question time, but happy to entertain as many as we can.
Absolutely. Great job, Kristina. I think we have time for one or two questions here. So first question is, do you have any tips on how to approach the legal aspect for digital apps and products that are for a global audience?
Oh, wow. I'm going to encourage that person to reach out to me separately, because that's a really broad question. And I think I would need more information as to what specifically you're asking about. I mean, I guess the short answer to that question is, the WCAG criteria are the pretty universal international, not standard, since it's different as to what's accepted in different places, but it's pretty much everywhere around the world. If you follow the WCAG criteria, you're going to have your technologies be as accessible as possible. But drilling down from that, obviously different laws apply in different places. So I need to know a little more specifically what you're thinking about.
Great, thank you. Question here is the most upvoted question, so we'll go with this one. Do you have any information about the status of accessibility overlays in the legal realm?
Oh, so the status is, just like everything else we talked about today, as far as lawsuits, right? It depends on what court you're in. But there have only been a couple of courts that have heard cases where an overlay was at issue. One recent one was a Paguada case out of New York, where the defendant tried to dismiss the lawsuit on the basis that it had the overlay making the website accessible, and the court said nope. But mind you, that was at the motion to dismiss stage, so that means before there was actual fact finding. And there have been a handful of other cases involving overlays, but we don't have an actual dispositive decision yet saying, an overlay is fine, or an overlay is never going to make a website accessible, or it's going to make it worse, anything like that yet. But we are starting to see more cases litigated where an overlay was the attempted solution to make the website accessible.
Great, thank you. All right, we are unfortunately at time. Kristina, thank you so much for your presentation today. And thank you everybody for your great questions. I'm sorry we didn't get to all of them, but please enjoy the rest of your AxCon experience, and thanks again.
Thanks, everyone.